All right, buckle up. The judge is already irritated, the defendant is confused, and we're opening this courtroom drama with a classic, showing up late and picking up new charges while on bond. Let's see how fast this escalates.
What time does court start? Mr.
8:30.
What time did you get here?
I didn't have to come today.
Yo tenía que comunicarme con mi abogado después de las 4.
After the 4th, I was supposed to communicate with my lawyer.
I ordered you to come here
Yo le
today
ordené
because you
venir hoy.
have a new case. You are on bond for an assault. You now have picked up a new assault. You are now facing another year.
Quick breakdown. The judge is laying out Miranda-style rights because they're moving into probable cause, which means the court decides whether the new assault charge even has enough evidence to move forward. And trust me, probable cause hearings can turn a bad day into a disaster.
And or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Defendant and the defendant dating relationship. On 11/27/24, officers were dispatched to an assault in progress in Harris County, Texas. Officer met with other officers who had already detained the defendant. The officer spoke to the complaining witness, who stated the defendant pulled her hair at the house and that she felt pain. She stated that they had been driving down Westheimer and the defendant attempted to take her purse that had a flash drive that had fraudulent scam material on it. Complaining witness said the defendant was trying to scam San Jose Gas Oil, and the information was on the USB drive.
Notice what's happening. Both sides are claiming they felt pain, both hint at aggression, and now a witness says she saw a fight in traffic. When multiple stories collide like this, judges look for consistency, and so far, there is none.
Complainant stated that they started to fight and she scraped her hand on the purse and felt pain. Complaining witness also stated no threats were made and the suspect did not put his hands on her. Defendant stated they were arguing in the car and the complaining witness slapped him twice and scratched him. Defendant stated he felt pain. The witness stated she worked security and she saw the traffic was backed up, so she drove up and saw the complaining witness and the defendant in a stopped car in the street. She said she saw the complainant and the defendant fighting. Complaining witness was trying to exit the vehicle and that's when the defendant pulled her hair. Witness stated the complainant exited and ran across the street and called 911. Officers observed blood on passenger window where complaining witness was sitting. Officers also observed complaining witness to have injuries to both hands.
Your Honor, no, the one thing I just wanted to point out was more on the dates, in that apparently he thought that the new case was set for December 5th. On this document, it refers to December 5th, but down the bottom, it looks like then it was ordered that he appear at the court's next docket on Wednesday, December 4th, because the original case that we had been here for, the first case, his appearance was waived on that case. So he got confused and thought it was waived, and I think.
Question for you all. If someone is already on bond for assault, should picking up a second assault charge automatically land them in custody, or should context matter? This is exactly what the judge is wrestling with right here.
We ordered him to appear because of the new case that he picked up. So regardless whether he comes at 8:30, he comes at 9:30, I don't think I've ever taken someone in for coming in at 11:30, for coming in at 12. But I do have a problem when you pick up a new case.
Yes, sir.
And it's alleged here that you have assaulted this person and they have now provided me with enough evidence that I'm going to find probable cause that it occurred. Joe?
Your Honor, the only thing I can say is the client has vigorous defenses. Obviously, that's not the appropriate point to point out. But I don't know, was the complaining witness out on probation at this time, or because she herself was under
Well,
legal?
all I know is that
Very
is
serious.
it 2 times that he pulled her hair, or was it just 1 time? It sounded like it was.
Just a one-time, Judge.
He was trying to prevent her from, she was gonna go out of the moving vehicle, was what his position was. He was trying to keep her from getting hurt, from going out of the moving vehicle.
Don't. I didn't hear anything about that.
Because I believe what happened is she called and reported this afterwards. They left the scene and then she called, phoned it in and reported it after.
So is she trying to jump out of a moving car and he's pulling her hair to keep her in? Well, but then the witness sees them outside of the car arguing and then he pulls her hair outside of the car.
I heard that. I did hear that,
So
Your
the
Honor.
witness saw the defendant and the complaining witness inside the vehicle fighting. The witness tried to get the complaining witness out of the motor vehicle, and then the defendant
Picked up a new
pulled her back
case.
by her hair.
Are we supposed to be happy you're on bond for an assault and you pick up a new assault?
Yo no daría daño nunca a la persona que
Well,
quiero.
now is, I mean,
I would never hurt somebody that I'm with.
Por favor, me refiero que diga su señoría. Ella es mi novia. Ella ahora mismo está en la prisión.
She's my girlfriend. She's right now in jail. He has
Porque ella está enviciada en la droga.
she has problems. She's drug addicted to drugs.
Yo quiero que ella lo
Hey,
hospitalice.
I want her to be
Yo soy la-
hospitalized.
yo soy la-
you,
The only reason that was relevant, Your Honor, if I could help him out, is that he did tell me beforehand to help the court and the system, is that she has been his girlfriend for many years, and that he has one child he supports along with his mother, who's here today, and he works as a driver, and he does support them all. But she does have this problem with drugs and has this pending case. He himself suffers from depression and diabetes, but he does manage to work in order to support them all. If these are just things that maybe the court could consider, because it would be a real hardship for them to lose the income. Now, he would agree to any kind of additional controls in terms of staying away from her, but you know, maybe 200 feet away or things like that. Because she's not living with them. The child is not hers. It's from a previous relationship that he supports. But they're actually two. One is 7 years old. One is 7 years old, and the other one is 3 years old. And so we're talking some very fairly young children that's in his custody. Now, his mother has been helping maintain him. She's back there on the
The
second.
complaining witness is currently in jail. I believe in Paris County Jail. I'm
this
trying to figure
complaining
out what
witness?
for. Yes, sir. I'm just trying to figure out for what, all I see is an out-of-county charge, so maybe there was a warrant.
given a cause number?
So it shows up kind of weird. I have like an out-of-county cost.
That's okay,
number, but
just-
I don't know if it will show up.
Is it a 2? Is it a 3? What?
No, it's like OOC.
No, that's,
Yeah.
huh?
See if I can
Sorry,
show it.
Mr. Lucas.
Yeah, you can look up, yeah.
No, no, sir.
Austin.
Yeah.
0326
hold on.
Austin.
0326?
8412.
Said it was Austin, Your Honor.
No, it didn't pick up.
Here it comes. The judge is shifting from hearing evidence to delivering consequences. The key phrase, I ask you to be safe in my community. Translation, the bond is in serious danger.
0326 8412?
Possession of
Yes,
substance.
No, I didn't get it.
It says that she's currently in Harris County Jail as of 11/27.
Do you have a cause or do you have a spin?
It's not, the spin number is, it's 03268412. It doesn't come up on here.
268412. That's the spin I have.
No. For me, it's not coming up. Let me try this. 3.
It
No.
looks like she was booked in, November 28th, but that's everything I see.
Booked in what day?
November 28th.
Yeah, so what happened if they got arrested together?
That's all I see. So it's gonna be another.
She's got, see or no?
Yes.
She's got a less than a gram case wherever.
Okay.
So she must have had an open warrant for a less than a gram case as well. Mr. Tujaquez, all I asked you to do was be safe in my community. You've now picked up a new case. I'm not going to let you go. You picked up a new assault. Doesn't matter who it is. Doesn't matter where it is. We ask you to behave yourself. And when you pick up a new case, that's not a good thing. And if I let you go, that is telling you it is okay to do what you're doing. And it's not. There has to be consequence to action so that you understand we mean business. If this person is like that, then you know, or you should know,
Yes.
not to associate yourself with this type of person. Do you understand?
But please, my family depends on me.
Then this is what you think of beforehand. You don't think about this after the fact.
But I didn't do anything. I wanted to help her.
I'm not going to talk to you about the case. I'm not going to know. Now, I will tell you this, that I had already revoked your bonds and I was going to set them both at 10,002, but I won't do that. I'll entertain a lower bond with you, Joe. I mean, what do you think is appropriate? I want you to understand that I'm going to take you in because I want you to understand that public safety is my number one concern. That's it. As a courtesy for your lawyer, and because of what you're saying, I will not set it as high as I was going to, and I will entertain a lower bond. But you picked up a new assault.
Your Honor, would you consider $1,500?
State, what do you think?
Judge, I'm just gonna argue for a general $5,000 bond. This individual was told obviously not to pick up any new cases and he picked up the exact same kind of case while on bond previously.
All right, so what I'm gonna do is I'll split the puppy, okay? And on the new case, he's at 5,000 now on the old case. I'm gonna revoke that PR bond. I'm gonna set that one at 5,001. And then on the new case, I'll do it 35.
This is the moment everything tightens. The judge is lining up strict conditions, protective orders, and a crystal clear warning. One wrong move, and he's going to go bonkers on the bond. What do you think? Fair warning or harsh overkill?
1 as opposed to 10,002 on both of them. And that is, Joe, you know, I hope that you now understand that we mean business. And no matter what the excuse, no matter who you're with, when you pick up a new case, there are consequences.
Yo le prometo que usted no va a ver más nunca. Problema, yo nada.
Promise I won't cause you any more problems. You won't see me for something like this again.
I hope you show back up to court.
Es serio, ¿no?
Espero que
En
sí se
serio.
presente.
Stay in contact with your
Sí,
lawyer,
claro, sí, claro,
Of
claro.
course, of course.
and from now on,
De ahora en adelante,
as a part of your,
como parte,
Le pido una disculpa
don't.
porque yo el día 4 no tenía mi corte.
Tú, Jaques, no habla. I want you to listen. I don't want you to have contact with the complaining witness in this case. I do not want you to be in possession of any weapons. You are also not to have contact with the complaining witness in the first assault case. If you pick up a third case, I am telling you now, I will go absolutely bonkers on your bond. Do you understand?
of course.
The only reason I'm making the bond as low as it is now is because of Joe. Otherwise, your bond would be at 10,002. But as a courtesy, but I will have absolutely no qualms whatsoever if you pick up a third case. Who's the complaining witness in the first case?
I think he's just an employee of a business at a car dealership.
Okay, all right, goes with you. All right, okay, Joe, we'll talk soon. So, hey, he's gonna auto-populate tomorrow. What? Oh, yeah, oh, shit.
Can you bring him over here?
I didn't realize it was a family member. I'm sorry, Stephen. I forgot there's a MOAP that we need to enter in. Come on back.
Are you gonna speak to him?
No. Joe, sorry. Where's Luis? Sorry, Luis. I forgot to do the protective order. Let me see. Has it been entered?
It's in there.
All right, here we go. Mr. Tujakas Palomino, I'm now entering in a magistrate's order for emergency protection. This is a court order that identifies Ms. Ramos Sabarit as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you get out of jail and if she should contact you, if she calls you, do not answer the phone. If she calls you from an unknown number and you answer the phone and it is her, hang up. If she texts you, do not reply. If she comes to your house, do not answer the door. If she gets a hold of you through social media, do not answer. You're the one. If you violate this protective order, the state can and possibly will file a violation of a protective order. You violate these conditions, I can have a hearing to hold you at zero bond. Zero bond. And I will do it in a heartbeat to protect every person of this county. Do you understand? Are you sure?
Yes.
Okay. All right. Thank you, Stephen. Sorry.